Okay, let's get started. So, welcome everyone online to our panel today. Climate Justice, the Court of Appeal decision in Mathur versus the Queen. So the case, as those of you are familiar with it, raises really one of the existential questions of our time, dealing with climate change. In the case, a group of Canadian youth have challenged the Ontario government's decision to roll back its greenhouse gas emission reduction targets. And Canadian youth have challenged this as a violation of their Section 7 and Section 15 rights. And so today we're going to talk about the Ontario Court of Appeal decision, which agreed with some things and then indeed sent the case back to the trial court for further reconsideration. I'm Brenda Kosman, Professor and Associate Dean of Research at the Faculty of Law, and I will be the moderator for today. We are joined by a very distinguished panel of 4 U of T speakers, who I'm going to introduce in the order in which they will be speaking. First, we have Cheryl Milne, the Executive Director of the David Asper Center for Constitutional Rights, which was in fact an intervener in the case. And then Professor Kent Roach, both of whom will speak about the constitutional dimensions of the case and some of the remedial questions that are raised by the case. We're then followed by Steve Lorteau, a doctoral candidate at the faculty, and Dean Jutta Brunnée, who will both focus on the environmental law and the international law implications of the case. Each speaker will talk for approximately 8 or 9 minutes, and we will then have an open question and answer period. I would ask that you put your questions into the little Q&A box that is on your screen. I'll be able to then collect those and present them to the speakers for the Q&A session. So with no further ado, let me hand it over to Cheryl Milne.
Thank you, Brenda. It's a pleasure to be here. I'm going to try and talk about, first of all, the sort of characterization of positive versus negative rights in the case, and that it was essentially sent back primarily because of what the Ontario Court of Appeal said was an error by the trial judge that characterized this as a positive claim for the government ought to do something as opposed to a negative rights claim. I'm also then going to talk about, in particular, the Section 15 analysis. That was an issue upon which the Asper Center intervened. And if time permits, I'm going to talk about a little bit about the procedural issues of sending it back at this stage. So first of all, with respect to this positive versus negative rights characterization, there is other climate justice cases out there, one in particular in Canada, the La Rose case, which has also been characterized as a positive rights case, where the claimants we're basically saying the government ought to have a better scheme, and as opposed to challenging a very specific law. My view of what the Ontario Court of Appeal has done is really an oversimplification of what is negative versus positive rights. There are in both Section 15 and Section 7 claims rather, positive and negative aspects in both of those kinds of claims. And by just saying, well, the real error here is just this negative, the failure to see it as a negative rights claim, I think misses out some of the things. And I expect Professor Roach is going to pick up on that in terms of remedy as well. For example, under Section 15, claim for equality, accommodations are a positive obligation on government, and the Eldridge case really speaks to that. Under Section 7, the principles of fundamental justice could also require positive action by government. So to really sort of characterize this as so clearly just a negative versus positive rights, I think misses out some of that, the nuance and character of our rights. It also relies on the government voluntarily wading into and developing a scheme through legislation, and leads to the conclusion that they could just repeal it. So if rather than tinker with this legislation, the government had come in and repealed everything and said, we're not going to do any of it, that essentially takes away the claim based on the analysis by the Ontario Court of Appeal. I think that that's a superficial reading of a quote from Sharma. The Sharma case was one of the cases upon which the Ontario Court of Appeal relies, and talks about that. And so in paragraph 39 of the judgment, the quote is that similarly, the Supreme Court in Sharma confirmed that Section 15.1 does not impose the general positive obligation on the state to remedy social inequalities or enact remedial legislation. And I think that that's just an overstatement of what we expect government to do. And I think that it also really gives us a very superficial view of what Section 15 is all about. The court basically then says is that the question before the application judge was not whether Ontario's target did not go far enough in the absence of a positive obligation to do anything, but rather that she should have considered whether given Ontario's positive statutory obligation to combat climate change, that it had voluntarily assumed the target was charter compliant. And although that to some extent I agree with that, I mean, she did err in failing to consider the correct question. I mean, I would see it more as that this was a case in which there was a direct challenge to a piece of legislation, as opposed to a more amorphous claim of the government ought to do something. And I think that's a different way of characterizing things than just this positive versus negative rights claim, because I think that that's too narrow. And the other aspect of it is you have to ask, so how is the scheme defined? And as I said, you could just say, well, it's this one piece of legislation. Once they repeal it, then there is no charter claim anymore. But if you look at what the court did in Sharma, so Sharma was a case in which there was a challenge to the failure to be able to provide or allow for a conditional sentence for a First Nations woman who had been convicted of a drug trafficking charge. And the conditional sentencing provisions had previously allowed for that kind of sentence in the circumstances of the crime, but then an amendment came through and repealed that. In the Sharma majority, and this was a 5-4 split about whether Section 15 applied, so it was a very, very divided court. The majority had very narrowly defined it as a conditional sentencing regime and excluded the Gladue principles, which would have taken into account her First Nations heritage in that scheme, which would be what we would consider being part of the overall criminal sentencing scheme. So they just narrowly said, no, this is a conditional sentencing scheme, and kind of excluded those Gladue principles. And that, and therefore, that led to them saying that the Section 15 breach was not there. The dissent, though, in its analysis, specifically included the Gladue principles and provisions in their analysis. So this is just an example of how once you define the scheme, and if you not define it too narrowly, then the rights themselves become less robust. So that's one question. While I do agree that this case is more squarely within the confines of typical charter litigation, a piece of legislation and the regulations under it are being challenged as unconstitutional, rather than what I've said is that a more amorphous claim that the government ought to act in a certain way, there are still problems with having it sent back on this basis, because again, it's too narrow. The other example of cases that the court has done that to, or found it to be just a positive rights claim is the Lorteau case, as I mentioned earlier, but also previously Tanajaja, which is a case around housing rights. And again, it was a claim against both provincial and federal levels of government, saying that there ought to be a scheme. So briefly then moving on to the Section 15 analysis, because I think that that's positive negative rights characterization then flows through. It was alarming, though, that the applications judge in its characterization of the claim as a positive right, seemed to adopt the most troubling aspects of the Supreme Court of Canada's majority decision in the Sharma case. And while I'm not certain that the Ontario Court of Appeal hasn't picked up some of them in respect of its comments on the evidence, in particular in causation, at least they've corrected some of that problem. For example, it's not clear to me that the evidentiary basis for showing a positive obligation differs from the negative characterization. And so sending it back for that, I'm really not sure why the court wasn't actually in a position to make the ruling based on all of the evidentiary findings. The other piece about Sharma is that the minority had been really critical of what the majority did. And I do think that the Ontario Court of Appeal has addressed some of those concerns in its reasons in the case, especially the role of interveners, the evidence, the reassertion of the proper approach to the substantive equality analysis that is more flexible and less onerous at the first stage of the test. But I do have this concern. And just in my last sort of 30 seconds or so, I just want to say that part of that, my concern about sending it back, is that I think the evidence was there that they could have made the rulings on the law, because it really is, it was overturned on legal reasons, and there were really strong findings of fact that would have supported the claims themselves. I think it was, they base it on an overstatement of the Supreme Court of Canada's decision in the Canadian Council for Refugees case, which a case that was sent back on the Section 15 basis, because the court below made no rulings on Section 15. Not that there were that they just made none. And I think that they've taken that as the basis for sending it back when it was a very different set of contexts. And then finally, my last comment is that it's just really an example of litigation, both on behalf of children and youth, and in the kind of urgent situation that we have with that we just can't really look to the courts, because this is going to take a long time for it to get sorted.
Thank you, Cheryl. And now let me pass it over to Professor Roach.
Oh, thank you, Brenda. Yeah, I mean, look, as you said in the introduction, this is the existential issue of the times, and I find it helpful to think back to Brown and Brown 2, where I think the historical record is really quite clear that the Supreme Court of the United States was not willing to take on racial apartheid until it had decided to go slow on the remedy and to remand it back to the trial judges throughout the United States to deal with it in all deliberate speeds. So, I mean, what strikes me here is that Ontario seemed to argue this is not justiciable. Climate change is not justiciable because the only remedy is for the court to manage climate change policy. And so I see the Ontario Court of Appeal decision as a small but important step in the right direction in saying no. There are manageable remedies in order to deal with this, and I think that that's important. The Asper Center tried to do that in Tanajaja. We didn't have as much success with the Court of Appeal as the litigants in Mathur did, but it is, I think, only one step. And going back to the analogy with in all deliberate speed, I think what I find concerning from the Court of Appeals decision in a remedial perspective is that it seems to suggest that a simple declaration is going to be the only remedy that's available. So it cites Cotter and it cites Eldridge. And certainly declaratory relief is in many ways our preferred constitutional remedy. both of those cases, Cotter and Eldridge, reflect a preference for declaratory relief. But I worry that a simple declaration on the remand could be kind of the all deliberate speed order of the 21st century. And what I've been urging now for quite a long time is that we need an intermediate remedy between the declaration that simply says, you know, what the government's done violates Section 7, Section 15, and an injunction, which is an enforceable order that has to be clear and specific, because in theory, it can be enforced by the court through contempt of court. And so I take comfort, some comfort in the fact that in two other decisions that were rendered this year, the Ridhima case from the Canadian Supreme Court and the Thomas case from the BC Court of Appeal, that I perhaps optimistically see both of those as recognizing that a declaration plus is an appropriate intermediate remedy, and one that is particularly suited to a context that is polycentric and dynamic. And I think I'll defer to others on the panel who know more about climate change than I do, but my understanding of climate change and what is necessary so we don't burn up is that it is a dynamic issue that changes every year, that we do not have effective remedies. So what I would urge the court and the applicants to think about is convincing the court that, as the Supreme Court of Canada said in the Ridhima case, a bare declaration is not an effective remedy, and that you can have a declaration plus in a manner that is fair to the government and respective of the roles of courts, legislatures, and the executive. Now, the problem here, and we've even seen this in some of the European litigation, the Jutta case in the Netherlands, is that courts are reluctant to retain jurisdiction. So in the Jutta case, the Dutch courts refused to retain jurisdiction, even though this was a very dynamic case that really required the government to go back to the drawing table and to come up with a new emission target. I think if you look at Eldridge and Cotter, the two cases relied upon by the Court of Appeal, both of those cases, I think, arguably resulted in kind of remedial failure. So in Eldridge, the BC government went beyond the 6-month deadline to come up with sign language interpreter for medically essential services. And many provinces, other provinces other than BC, seem to have no response at all. In Cotter, of course, the court said, we're not going to order that Omar Cotter be returned from Guantanamo. We're going to rely on a declaration. But of course, that was a very dynamic situation. And despite some really noble efforts by Justice Zinn on the remand, Omar Cotter had to eventually take matters into his own hands by pleading guilty as the only remedy that was going to get him out of Guantanamo. So it seems to me that on the remand, one of the challenges is to encourage the court to recognize that there is a range of constitutional options that the government has to, at least as first movers, come up with that constitutional option. But as in Restool, the way the government goes about coming up with this option and the substance of this option will then be subject to judicial review, given that this is judiciable, given that there are facts, and to try to come up with an effective remedy for the applicant. So there simply isn't enough time for there to be new follow-on litigation. And I think that one of the challenges will be to persuade the court that a declaration plus is an appropriate remedy. Thank you very much.
Fabulous. Thank you, Kent. So we will now move on to our next speaker, Steve Lorteau.
Yes, thank you. So I'm going to speak on the climate law dimensions of the Mathur decision, and I'll try to situate Mathur within the broader trend of judicialization of climate policy, both in Canada and abroad. So before us going into Mathur specifically, let's maybe go back to maybe 15 years or so, where you had in the sort of post-Kyoto era, this era where the federal government was starting mainly implementing plans. You didn't have the mandatory emission reductions obligations. You did have some sort of sectoral approaches were mainly focused on energy efficiency standards. And in that era, you had some early attempts at climate litigation. So in 2008, you had the Friends of the Earth case, of course, and the federal government there said that enforcing Canada's obligations under the Kyoto Protocol was non-judiciable, mainly because there was no law there to ensure that you have court enforcement. Then fast forward to the TERP decision in 2012, and there you had the federal court again deciding that the federal government's decision to withdraw from the Kyoto Protocol was not a matter for courts. So in this era, you had lack of statute. They were mainly non-binding plans or intentions or reports. You didn't have that sort of legal anchor there. And you had the notion on the part of the courts that climate change was this complex, policy-laden area, largely outside of judicial scrutiny. In 2015, we had the Paris Agreement, which represented a change. You had the delegated nationally determined contribution regime that required some sort of essentially delegated decision-making where nations would contribute to a global target and growing acceptance of climate change, both the science as well as the urgency to act. And in response, you had the federal government implementing a federal price on pollution, or what is popularly known as the carbon tax nationally. You had provincial governments putting in their own climate change regimes and having some response there. And now, last year, we had the Federal Court of Appeal in the Lorteau's decision mentioned earlier by Cheryl, who is really the first big Canadian case to go on the merits of a human rights climate change obligation case. And so we have Mathur as sort of the second big recent win on the part of climate activists, again going on the merits of Section 7 and Section 15. And not only that, they also opened the door for an analysis of Section 35 rights. You got the public trust doctrine. You got implications of international environmental law, best interests of the child, as well as the possible application of unwritten constitutional principles. So we've seen a big change between then, about 15 years ago, and sort of this post-Paris increased legislation of climate policy in Canada. Now, I'd submit there are maybe three main reasons for why this shift has occurred, and I think Mathur exemplifies these three reasons very well. First is we've seen increased legislative activity. So in Friends of the Earth and TERP, we didn't see that sort of textual hook. In Lorteau and Mathur, we both see this move on the part of the courts to search for some sort of legal anchor for the claims. And so in Mathur, for example, we had the Cap and Trade Cancellation Act implemented by the provincial government that showed that there's an assumption of a voluntary duty, that it's more than a plan, more than an intention, that there's this clear legal anchor and a target and a standard. Now, I should pause here and perhaps offer two critical commentaries on this point. One is there's a risk of a disincentive on the part of government and in part of putting in climate action. Insofar as if you require some sort of legal or textual hook to catalyze climate litigation, you are essentially creating a situation where the absence of legislation can shut the door to a certain degree towards climate litigation. So there is that sort of disincentive risk there. And you also got to wonder about the political process, for example, where, for example, in Mathur, we have the political process that may not offer great representation to, for example, the youth or the indigenous people who may lack the political clout of other actors. I'm going to put that to the side and just note for the moment that we have here more legislation to ground this sort of climate litigation. As a second factor, we have a judicial acceptance of the urgency of climate change as well as climate science. Now, I'll briefly note that in Friends of the Earth, for example, the case from 2008, we had the federal court actually list off, in some ways, Canada's failings in regards to meeting the Kyoto Protocol targets. But recently, we saw in the greenhouse gas pollution pricing reference almost 15 paragraphs in addition to an additional 30 recounting Canada's international obligations, the science of climate change, the various effects, and taking judicial notice of that. And in Mathur, again, we have the Ontario government, contrary to perhaps what we read about in the news at times, actually accepting that climate change is not only real, but possesses a variety of effects and actually has risks to health, human health and well-being. So things such as infectious diseases through Lyme disease and ticks, increased wildfires and floods, mercury poisoning, mental health impacts like eco-anxiety and the loss of cultural practices for Indigenous peoples. So in a way, we've seen a shifting of debate throughout the years of going from is climate change real or not, and these sort of vague discussions of climate change and how it fits into law, to more specific effects, causal issues, and consequences to be discussed by courts. And third, we see an increased acceptance of climate change itself as sort of this abstract issue as a matter for courts and judicial adjudication. So in LaRose, we have the Federal Court of Appeal saying climate change is justiciable, even if it is a complex and controversial issue. And in Mathur, we see, for example, climate change. Sure, it's a complex issue, like the example cited by the court of poverty and homelessness. But at the same time, you have this sort of international standard where you have scientific evidence by parties that are able to determine the acceptable levels of greenhouse gas emissions and the specific effects it has. And in this way, it is consistent with Canadian law, if you take a bird's eye view, where courts are dealing with controversial and big topics. You can think of prostitution, mandatory minimums, the list goes on, and even whether a province can secede from the federal government, right? So we have this trend in Canada, this big shift in Canada. That's one side of the coin. The other side is when you look at it internationally. And Canadian courts do seem significantly more shy than other courts in the world. So the Agenda case mentioned by Kent earlier, where we actually had the Dutch Supreme Court order maintain a 25% emissions reduction on national level on the national government of the Netherlands. So Canadian courts aren't there, nor are they at the European Court of Human Rights, where you have a finding that there was a failure to act on climate change and that it constitutes a violation of the European Convention on Human Rights. And in my own research, I can say that Canada generally follows the trend of more Commonwealth or common law courts, especially outside of the global South, that are generally more reluctant and shy to deal with climate change. But we are seeing this trend towards increased judicial involvement. Of course, that raises a host of institutional capacity and legitimacy questions. But just looking at Mathur, you do see this move towards increased judicial involvement. And in that way, that is going to stimulate more climate litigation going forward. Thank you.
Fabulous, thank you. I'd just like to remind the audience out in Zoom world to put your questions into the Q&A box, and we will turn to them for the question and answer session. Last and decidedly not least is Dean Jutta Brunnée.
Thank you, Brenda. Well, so I can really kind of double down on some of the things that have been said along the way. First of all, the role of science, but also what I see as a kind of growing pattern of judicial activity, maybe not exactly around the globe, but certainly extending beyond Canada and extending internationally. And what I found interesting in reading Mathur is how international law, let me put it like that, and I'll specify why I say that maybe in a slightly qualified way in a moment, comes in and is brought to bear in the decision. And I see Mathur really as one in a kind of growing series of decisions that draw on, I'll just use one example, on parts of the Paris Agreement to then harness existing law, existing rights and obligations. Now, let me step back a little bit and just say on the point of science that we were just reminded again a couple of weeks ago by the United Nations Environment Programme that we are suffering internationally from what you might call an emissions gap, or what UNEP calls an emissions gap. So reference was made to the Paris Agreement. Under the Paris Agreement, parties are required to give their nationally determined contributions, so make commitments every 5 years. The idea is that they will be progressively more ambitious. And what UNEP told us 2 weeks ago is that there is a massive gap between the rhetoric and the reality, and that really what has to happen is a dramatic increase in ambition. Why did it do that? It did that because we are coming toward the next meeting of the parties to the Paris Agreement, where the next round of nationally determined contributions will be on the table. What is clear, and in terms of scientific consensus, and that's been confirmed by the Intergovernmental Panel on Climate Change, which is essentially a body encompassing some 2,000 of the world's leading experts on climate change, that we need really sharp cuts in emissions in the short term, in the range of 45 degrees by the end of this decade. And also in the medium term, coming to something like net zero emissions by 2050. And we need to do that in order to bring greenhouse gas concentrations in the atmosphere to a level that gives us a reasonable chance to stay within the 1.5 degree temperature target that has been now, I think, universally agreed to be the safe zone. If we go beyond that range of temperature increase, we have potentially catastrophic and irreversible changes in the global climate. Now, where did that target come from? Scientifically speaking, from bodies like the IPCC, but legally speaking, it is enshrined in the Paris Agreement, and the parties to the Paris Agreement have over and over agreed that this 1.5 degree target is the one we need to meet, and that requires rapid, deep, and sustained emission reductions. And when you read Mathur, the lower court and the Court of Appeal, that's actually set out in quite some detail here. And so that brings me to what I found interesting about Mathur, which is how courts are finding ways to give legal traction to this 1.5 degree target and use the target to provide guardrails for what has to happen in terms of emission reduction. Now, why is that noteworthy? As an international lawyer, I would say the temperature target in the Paris Agreement is not binding in international law, and for that matter, neither are the nationally determined contributions that individual states take on. And yet the agreement, the target, has proven to be of real significance in domestic and international decisions. And Steve made reference to Urgenda, and Kent did as well, the European Court of Rights, the German Constitutional Court. There's a whole range of decisions that do this. I want to give you an example from international law to illustrate why I think there is significance to this and why this is a path worth pursuing. In May of this year, the International Tribunal on the Law of the Sea gave an advisory opinion on the legal responsibilities that states have to address climate change. And the focus here was on the Law of the Sea Convention, requiring protection of the marine environment. An organization of small island states had requested this advisory opinion, and the key question was, what is the standard of conduct that states have to adhere to in their efforts to protect the marine environment from climate change? Briefly put, much of the debate was about due diligence that states have to exercise, and the tribunal then proceeded to detail what factors would determine the standard of conduct in relation to climate change. And among the various factors that are relevant, the level of risk and the severity of potential harm, the available scientific information, available technologies, and so on are key. Now, perhaps you might see where I'm going with this. In the case of the ITLAS decision, so the tribunal decision, island states had spotlighted the universally agreed 1.5-degree target and the scientific information pertaining to the risks that attach to climate change. And the gist of the argument was that due diligence wasn't a matter of discretion, but it had to be determined according to objective criteria, and that given the level of risk and the potentially catastrophic consequences of overshooting the 1.5-degree target, due diligence actually subjected states to a stringent obligation. It required them to take measures that were capable of keeping emissions within the target range. And the tribunal agreed. It found that the target informs a stringent standard of due diligence. And so the target ended up being a factor in the analysis of what the general legal standard of due diligence required. And that's the way in which the target gained legal relevance. This has potential to unfold again. And in December of this year, the International Court of Justice will also hear a request for an advisory opinion on climate change. And this exact same issue might play out in the context of the harm prevention obligation under customary international law that's applicable to all states. Now, let me bring this back to Mathur to really make the main point that I want to make here. And that is what we see are efforts of varying kinds to go to court where you see litigants looking for ways to bring existing law and existing rights and obligations to bear on climate change and to find a legal hook for the international consensus on what is needed. In the case of Mathur, that's Ontarians' charter rights. And I would say more broadly speaking, what this pattern suggests to me really is that as many of us as possible should take up the invitation to consider all the different ways in which the unequivocal science behind the 1.5-degree target can be tied into existing law. And I think that's crucially important. Because we can see domestically and internationally that ambitious standard setting on climate change has been really difficult, to say the least. I'll add one final thing, and that is we also see the court in Mathur, both the lower court and the Court of Appeal and the international tribunals and the other domestic courts that I've mentioned, to really rebuff the argument that what we do here locally is just a drop in the ocean, so to speak. So there's a concerted rebuffing of the argument that the fact that climate change is a collective action problem where many have to pull in the same direction. Courts have consistently now rejected that means we should be doing, that it doesn't matter so much what we do domestically. So I do see an important pattern, but I'll close by saying Cheryl is also right in saying this is not the well, it's also a slow process, right? And especially now that everything has been sent back to the lower court, by the time we can, I guess, might be an interesting question. Should we imagine this going up to the Supreme Court of Canada? And if that's the case, how long will it take until we get an answer? Thank you.
Fantastic. Thank you all. And we will now move to a bit of a question and answer. We have a number of questions coming in the Q&A. So let me start. One question that just came in said, Kent Roach mentioned a declaration plus remedy. What would be an example of a plus?
Well, thanks for the question. A plus would be, could be a reporting back to the court. It could be a requirement for consultation. One of the things that Justice Zinn did in the Cotter case is he gave a deadline for the government to propose what it was going to do. He then allowed the applicant to comment on that, and he reserved the right to make the final order. I'm not sure if courts are going to be willing to do that in the climate change, that they're very leery about taking away the government's discretion. But in Restool, for example, Justice Jamal said, basically, you have 6 months to come up with an augmentation to the treaty. The government cannot ask for an adjournment. Only the treaty applicants can ask for an adjournment, and really tried to, I think, even some of the bargaining power about how that would be exercised, and sent a signal to the Crown that it was not only the substance of what the Crown came up with as a treaty augmentation, but also the process that it used. I think it is very important that there be wide consultation so that we don't go down these kind of false paths. So, one of the problems with a case like Little Sisters is it was a complex issue about dealing with censorship at customs. The court ended its jurisdiction, I think, prematurely, and then 7 years down the road, it goes back to the Supreme Court on a very preliminary issue, whether Little Sisters, as a small bookstore catering to sexual minorities, could get advance costs, and the Supreme Court said no. So I think one of the things is we have to get courts to realize that charter litigation like this is extremely costly, and that we cannot afford not to come up with an effective remedy. But at the same time, there is a range of remedies, although some of it depends on the latest scientific information. And so I think courts need to think about something where they can be part of the solution, structure a process for the solution without necessarily being the solution. But if you go back to Restool, I think the Supreme Court made it very clear that if the government fails once again to come up with a constitutionally sufficient solution, then the court has an obligation to come up with a constitutional remedy. And so that, that I think it's important for litigants to think very precisely about what the plus is, and to make sure that the plus is consistent with all of the remedial principles, effective remedy, but also respect for institutional role and fairness to the government. So there's no one plus. The plus depends on the exercise of remedial discretion. But I would be very worried if at the end of the day, there was simply a declaration and the court says, that's it, we're functus, this litigation is over, because that puts a burden on plaintiffs to commence new litigation should the government's response to the declaration not result in an effective and meaningful remedy. Thanks.
Great, fantastic. Another question. I think this might be for Steve. How would you say UK law links or relates to Canadian law with climate change? Are there any stark differences or similarities? Is that over to you, Steve?
Yes, I'll take that question. So I've been tracking citations in climate litigation, and just as an empirical matter, I've only found one citation. I just looked at the database quickly, and one citation of a Canadian court citing some UK decision. That was in the Sierra Club Challenge to the BC Climate Accountability Report. So we're not seeing a lot of like explicit influence there. So far, citations to courts outside of national jurisdictions have been fairly rare. If I would make a bet, I would expect greater influence of the UK law in regards to parent company overseas environmental damage cases. That's an area where courts in the UK have been innovating and addressing novel legal questions. There's also a host of UK cases in regards to environmental assessment processes. That's unlikely to influence Canadian law. But as to the general point of the influence from one jurisdiction to another, we are seeing some evidence of that. The Canadian Supreme Court, for example, cites Massachusetts versus EPA from the United States, as well as a case from Australia and Urgenda for the proposition that the fact that an individual jurisdiction can't mitigate climate change on its own shouldn't foreclose the possibility of having obligations, right? The sort of drop in the ocean type argument raised by Jutta earlier. Now, you do have that influence. There are examples of that sort of transnational reach of national court decisions, but it is emerging as an area of practice, and we're probably going to see it evolve as the law evolves with it.
Fantastic. Another question. If the lower court analysis were to find a violation of Section 7 and/or 15, and then proceed to a Section 1, hypothetically, if it did, how would you imagine Section 1 going? I imagine that's maybe for Cheryl or for Kent. Maybe Cheryl, you want to start?
Sure, happy to. I mean, I think what what happened here was a bit extraordinary because the government didn't lead a Section 1 defense at all. And so now what the Court of Appeal has essentially alluded to is now they get a chance to do that, which is really quite surprising, right? The federal or the provincial government made a choice that they were going to argue this positive rights defense, and now they get another kick at the can. And it goes back to sort of one of the problems with the litigation is now we have a whole new case where they basically said that the government could choose to put in Section 1 evidence. What would that look like? I'm not really sure. I mean, they've essentially given up the argument against the evidence, right? That climate change is an issue that they must address, and so the pressing need for this legislation and the pressing need for the government to act is something that they've essentially conceded. So, what could they argue under Section 1 in terms of sort of counterbalancing? What could they demonstrate as necessary? It could be the financial aspects to it. It could be the economy, the impact on the economy in Ontario. But there have been other cases that have really downplayed that as a reason for not doing what one should do when there has been a clear constitutional breach. So I think to some extent they've got one hand tied behind their back because of the strategy they took. However, they get this other kick at the can, which I think is a real problem for the litigants, because they're now going to be litigating, even though their case was based on Section 15 and Section 7, and the the evidentiary findings are pretty strong for the breach. I think they're having to argue the Section 1 analysis all over again.
Great, thank you. So here's another question, I think maybe for Jutta. And this has to do with, so with Canada hosting the G7 next spring, how can the international community reinforce the consensus on how we need to reinforce the need for a firm and legal commitment to protecting our climate?
Yeah, and I think there was a follow-up clarification to that, I see. Yeah, Barbara, that's a good point. I mean, it's actually interesting if you go back. I think Steve went back 15 years earlier. I don't know quite how long back we have to go, but this 1.5 degree target that I mentioned has been quite some time in the making. The original climate agreement really only said that states should avert dangerous concentrations of greenhouse gases in the atmosphere. And then in order to quantify what that actually meant, science basically helped us arrive at this temperature target, which in turn allows us to go back and say, well, if we want to stay within that temperature limit, what are the maximum greenhouse gas concentrations in the atmosphere that we can have? This target, though, was agreed actually, and ultimately kind of socialized through a series of meeting communiques, including at the G7. So it's not unheard of that that happens. I'm not sure that we're in a world right now where the G7 is likely to go much beyond where things are, at the risk of sounding a little bit pessimistic there. And that's why it's so important that we have organizations like the UNEP with its GAP report and the IPCC, who regularly hold up the mirror to states when they meet to renegotiate their commitments now under the Paris Agreement, to basically show that there is a long way to go and much more is required. I guess I'll add only, and this is slightly beyond the scope of the question that you asked, but that this reinforcement of the relevance of something like the temperature target, for example, really is significant in its potential legal implications. And one illustration for me, again, taken from the international context as to why that is so, is that if you take the advisory opinion request that is now before the International Court of Justice, some 90 states have made submissions, and many of them actually try and argue this exact point, because what we're seeing here are efforts to make the unequivocal fact, so to speak, being brought to bear in existing law. So it's no longer about states negotiating this or that. And that's why it's potentially so powerful, even if it seems like there are small steps and we need big steps.
Wonderful. Here's a question that I think each of our panelists might be able to address, which is, are there negative aspects to the growing judicial activity on climate change? Cheryl, maybe we'll start with you.
Sure. I mean, I agree with all of the positive aspects that Jutta and Steve have talked about, in terms of especially some of the evidentiary findings that are really helpful, because it does hold government's feet to the fire to some extent by making these evidentiary findings. But I do, as we've seen with the delay that is occasioned in this case, but also just courts, and Kent would agree in terms of remedy, the courts' general reluctance to move too quickly in terms of remedy and to do incremental responses, including, I mean, if you look at, even there's a quote from Sharma that the Ontario Court of Appeal ignored, which is around Section 15. It's okay for governments to meet equality claims incrementally. That is a disaster for the planet. And so the real problem, and I'll just make one more point, is that so we can't rely on the judges to correct things and make it all go away. But governments have this tendency, when things are in court, not to do anything until the court has finally pronounced. So if we're going to have to wait for Ontario to step up its emissions targets in a way that is going to be meaningful till the Supreme Court of Canada releases its decision, then we're going to be, that's just going to be too long.
Kent? You're on mute.
I agree with what Cheryl said on remedies and the chance the courts will be too conservative or traditional. I would just add that, there's a danger that people will think that the courts have this issue and will not engage on this issue politically. And again, to go back to Brown versus Board of Education, there really wasn't effective remedies, especially in the American South, until there was federal legislation. And so I think that we are into, although it's not the most popular word these days, a dialogue. But what that means is that you need to engage politically at the same time that you engage judicially. But I do think that there is a danger that we will see this as kind of mutually exclusive routes. And we may, by going down the judicial route, we may find, unfortunately, that we went down the wrong path.
Steve?
I kind of had 2 points in regards to this question. I think first, there's always a risk for I guess, anti-regulatory or anti-climate precedent. So the United States, most famously, there was in about 2011, there was a public nuisance claim, essentially attaching nuisance law to climate change. And that decision by the US Supreme Court really shut the door to that sort of climate change nuisance claims in the United States. And this decision was actually cited as well in other jurisdictions like Australia and New Zealand. So there is always that risk of getting, I guess, a bad climate precedent on the books and then shutting that door towards future litigation. The other dimension is, I guess to cite Commissar on this point, but when we're asking about whether courts should be involved or other institutions, we also need to sort of compare and think about, the other options. And living in a world where we do see inaction from the executive, from the legislator, even the private sector, we are sort of left with courts as a sort of last resort in a lot of these cases. So there are, of course, pros and cons to courts, but sometimes that is the option we have in front of us.
And Jutta?
Yeah, following on Steve's last observation, I would say that there is a definite element here of the political process failing domestically and internationally, right? Like we see what's going on. It looks like we are at risk of moving backwards rather than forward in the face of all of this evidence. And so courts end up being the place where a lot of these issues that are not amenable, it seems, to political resolution get taken in the hopes of some kind of answer. So building on what Ken said earlier, invoking Brown versus education, it does seem to me that, and I've certainly experienced this in the context of the Tribunal on the Law of the Sea, courts and judges feel the weight of history, right, when these cases come to them, because these are not trifling matters and it is urgent. But at the same time, what are the downsides? So they are also conscious that what they do has to be carefully crafted so that it can survive, because the risk I see is that court decisions that go too far, or even go as far as they could, will lead political actors to pull back. So, for example, the Paris Agreement, for various reasons, was designed so that it was not legally binding, and yet see how it all of a sudden has gained relevance. And so the worry that one might have is that we'll see even further pulling back. But I want to stay optimistic and say we've got to act at all the different levels that we can, and courts are definitely one of them.
Well, that is an absolutely wonderful note to end on. Let me just end by thanking all of our panelists, Cheryl, Kent, Steve, and Jutta, for leading what I think has been a really insightful, fantastic conversation. There's been lots of really positive comments in the Q&A about this. And to the audience, thank you all for coming, and stay tuned for our next SNAP panel.